system in Minnesota. So we've seen little bits of hydrogen, 0.25%. So this isn't like new, but it's newer at a higher level. We believe
Senator Mann, we have a list of testifiers. Would you like to make some opening remarks, and then we can go into the testifiers?
Thank you, Mr. Chair, members. Senate File 2 establishes the Minnesota Paid Family and Medical Leave Program. It would provide Minnesotans with a 12-week leave at partial wage replacement to take care of a new baby, bond with a new child, or take care of a family member, and 12 weeks take care of themselves in the event of a major medical event. Out of almost 200 countries, the United States is one of 7 that does not offer paid leave, and the remaining 7 are largely micro-islands. The U.S. certainly is the only industrialized country that does not offer such a program. Currently, only about 13% of Minnesotans have access to paid family leave. The need exists, and the need is great. What we are currently doing is not working. Paid family and medical leave is good for families, it is good for babies, it is good for the economy, resulting in increased employee retention, and in the long term will help alleviate our workforce shortage crisis. Most people have heard this bill in introduction already here, so I will make it short today. I would like to introduce Mr. Chair, Ms. Deborah Fitzpatrick, who will give an overview of the parts of the bill under our jurisdiction today.
Thank you, Senator Mann. Chair Latz, members of the committee, my name is Deborah Fitzpatrick. I'm the Director of Policy and Research at Children's Defense Fund, Minnesota.
Go ahead, Ms. Fitzpatrick.
In a prior role, I was at the University of, when I was at the University of Minnesota, I led the research team that conducted Minnesota's legislatively mandated design and implementation study on this issue. So I'm just going to run through quickly at a very high level the areas of the bill that are under this committee's jurisdiction, and obviously we'll have a conversation about those later. So Article 1, Sections 1, 4, and 5 relate to data, making the data related to this program private, allowing data sharing between DLI and DEED for purposes of administering the program, as well as between the UI program and paid family and medical leave, again, to administer the chapter. Section 12, Subdivision 4 allows appeal to the Court of Appeals after exhausting administrative appeals processes. That is similar, again, and lifted from the UI program model. Section 14, Subdivision 8 provides remedies that are substantially similar to those available under FMLA for violations of employment protections for workers taking eligible leaves. Section 15, Subdivision 13 provides permissive penalties on employers that violate requirements under a private plan exemption. And employers are allowed to offer a comparable program if they submit a plan and get that approved by DEED. Sections 17, 21, and there's, I apologize, 22, 26, 20, there's some, I was looking at the wrong version of the bill, so sections 28, 29, and 30, all of these sections are modeled on UI statutes providing similar processes for appeals, collection of funds due to the department from employers or workers, processes for obtaining information necessary to administer these processes, dealing with child support, et cetera. So again, all of those are designed to be modeled after UI processes for similar reasons. So with that, I'll be available later.
All right, Senator Mann, would you like us to just call the list of testifiers that we have? All right. Then we're going to ask Katie Kramer to come forward and Leah Midgarten both to come forward and take a seat. We'll start with Ms. Kramer. So Ms. Kramer, if you go ahead and identify yourself for the record and state your name, and then go ahead with your testimony. Thank you.
Chair Latz, members of the committee, I'm Katie Kramer, Director of Operations for Violence Free Minnesota, the Coalition to End Relationship Abuse. We are a statewide coalition with over 80 member programs who provide advocacy and direct services to domestic and sexual violence victim survivors in all of Minnesota's 87 counties. I'm testifying in support of Senate File 2, the Paid Family and Medical Leave Program, and want to highlight the need for safety leave provisions for survivors of domestic abuse. Surviving abuse and navigating its aftermath is dangerous, traumatic, expensive, and time-consuming. Survivors need time to address their medical and safety needs, such as accessing health care, attending counseling, obtaining legal services, meeting with an advocate, and/or relocating their housing. These are essential for immediate safety and to help survivors sustain stability after leaving a violent situation. Yet when survivors take these steps to protect and care for themselves and their children, they often run the risk of losing their employment or much-needed wages as a result of missing work. This is a serious contributing factor to the dynamics of financial abuse and can force a survivor to choose between leaving an abusive situation or facing potential homelessness and the loss of other basic needs. Not having safety leave available for survivors creates a threat of financial instability and prevents survivors from accessing vital services. SF2 establishes vital supports for survivors of domestic abuse. Paid safety leave provides survivors with the employment security and financial protection they need to address their health and safety for themselves and their children. We urge you to pass this much-needed legislation as a step towards ensuring stability for survivors of violence. Thank you.
Thank you, Ms. Kramer. If Mary Jo Maleka could come forward, you'll be up next after Leah Midgarden. Ms. Midgarden, go ahead and identify yourself for the record.
Good afternoon, members of the committee. My name is Leah Midgarden. I am the field organizer for the Southeast Area Labor Council, and I live in Red Wing, Minnesota. When I was working for a large private Catholic university, I received an email that I was only that my employer was only obligated to pay no more than 8 weeks. Now, I was formerly the research director and labor caseworker for the late Senator Paul Wellstone, so I knew they were wrong, despite repeated assurances that this policy had been reviewed by highly trained, professional, skilled, and probably very expensive lawyers. I had to do my own research, and I was subsequently able to provide for them what was at the time the most recent administrative law ruling pertaining to the application of sick and vacation leave to sick and vacation time to FMLA leave. In short, I got paid for 12 weeks. A worker's ability to access the benefits to which they are entitled should never, ever rely on risking intimidation, being fired, or poor treatment from their employer. Additionally, attempts to create exceptions and exemptions to paid family medical leave policies leave workers vulnerable at a time when they need and deserve support. Seeing an infant's first smile, holding the hand of a beloved father at the end of life, being able to heal and get well without fear of losing income. These are all things every single Minnesota family deserves, no matter who we are or where we come from. How we choose to invest in policies like paid family leave show what and who we value. Please vote yes to move this bill out of committee today.
Thank you, Ms. Midgarden. While she has left the seat, if Ms. Potter, Chaneda Fangdara Potter can come forward, and then the Mary Jo Maleka, hope I pronounced your name right. Go ahead, please.
Good afternoon, Chair Latz and members of the committee. My name is Mary Jo Maleka. I reside in New Brighton, and I'm testifying on behalf of myself this afternoon. My first child was born 38 years ago. I'd been living with type 1 diabetes for 12 years, so it was considered a high-risk pregnancy. After experiencing preterm labor and blood pressure spikes, my doctor decided it was safest to deliver my son early via cesarean at 37 weeks. We were both doing well, and my doctor said I could return to work 8 weeks after the surgery. Sadly, my employers, when informed of this great news, told me I needed to be back at work 5 weeks postpartum because I had, in essence, started my unpaid maternity leave when I left the company to be on bed rest. I told him that my doctor advised against returning to work 5 weeks after major surgery. I asked them to let me extend my maternity leave to 8 weeks after giving birth. They refused. I asked point blank, if I don't come back to work at 5 weeks postpartum, will I be fired? Yes, they said. Even though the financial ramifications for my young family were severe, I did not return after 5 weeks, and I was fired. I never would have believed that what happened to me 38 years ago would still be happening to women today. Unfortunately, it still is. Women in Minnesota are being told they need to get back to work just weeks after giving birth, or they will lose their jobs. The pandemic exposed this problem across the country because so many companies denied paid leave as schools, child care centers, and elder care facilities shut down. Women were forced to leave the workforce at twice the rate of men to care for children. I simply don't understand how some legislators aren't doing more to connect the dots between the workforce shortage issues and how this bill will actually help worker retention. The time for paid family and medical leave is long overdue. Minnesotans overwhelmingly support PFML across party lines. I encourage you to work for the passage of this bill. Thank you.
Thank you, Ms. Malika. While Ms. Potter is preparing to testify, if Renee Herskovitz could come forward, please. Ms. Potter, go ahead and identify yourself for the record.
Yes, good afternoon, Chair Latz and members of the committee. My name is Janita Pigdara Potter, you're close, and I'm the Vice President of Communications and Narrative at the Women's Foundation of Minnesota. Thank you for the opportunity to testify today in support of paid family medical leave, which I believe and we believe at the Women's Foundation is a comprehensive, publicly administered program for working Minnesotans who need access and coverage the most. I come here today not only as an advocate, but a worker, a mother, and a caregiver for my family and my extended communities. For the last 40 years, as the first statewide foundation dedicated to gender and racial justice, the Women's Foundation of Minnesota has invested more than $45 million in organizations across the state that work directly with women, girls, and gender-expansive people and their families, centering racial gender justice. From our groundbreaking research with the University of Minnesota Center on Women, Gender, and Public Policy, we know that paid family medical leave is one of the most critical solutions to thriving families. Our data shows that women make up 59% of Minnesota's workers who are paid at or below the minimum wage, with majority concentrated in rural and greater Minnesota and in the service industry, with 58% of Black mothers and 46% of Native American mothers being the primary breadwinners and head of households. Not only are they poorly compensated, they also lack access to basic benefits. On our path towards economic justice at the foundation, we listened to our communities on the ground who told us to invest in holistic well-being, healing, as part of economic justice too. So we know wealth building consistently shortchanges our Black, Indigenous, Latina, immigrant, and other women of color in intergenerational poverty, which is not something we want to stand by or continue seeing. As an immigrant growing up in North Minneapolis, I saw my parents, my sisters, aunties, and fellow community members lose money, lose their jobs, and their sanity because they couldn't afford to care for their loved ones. This includes caring for my father when he collapsed on the assembly line while I was working at a restaurant as a teenager, and recovering from the birth of my 2 children while I was still a grad student. So as you can see, these are stories within the data, and it's the reality for hundreds of thousands of Minnesota's caregivers. When they're centered and supported, the impact is transformational to their entire families and their communities. A robust paid family medical leave means workers do not and should not have to choose between caregiving and the next paycheck. So I know, surviving through this pandemic alongside with all of you, that Minnesota has long been a home to where a culture of collective care for our neighbors is an intrinsic value of ours, and we can't risk a vulnerable workforce to our lack of care for each other. So if we truly value the women and caregivers who make this state thrive, I, along with my colleagues at the Women's Foundation Minnesota, ask this committee to move quickly to pass this bill so that hardworking Minnesotans like yourselves can focus on caring for their loved ones and themselves, which leads to a better and more thriving Minnesota. Thank you.
Thank you, Ms. Potter. And while Ms. Herskovitz is preparing to testify, if Caitlin Rogers could come forward and take this seat. Ms. Herskovitz, go ahead and state your name and present your testimony.
Mr. Chair and members, thank you. My name is Renee Herskovitz. I've been working in the hair industry trade for 22 years as a hairstylist, educator, manager, and now a salon studio owner. I'm also a Main Street Alliance member, and I'm here in support of File 2, the Universal Paid Family Medical Leave Bill. Benefits have always been hard to come by, especially for someone working in a non-unionized trade like myself. As an employee, I experienced minimal health benefits and was never offered disability or any type of paid medical or family leave. As a self-employed small business owner, the options available to us are more expensive and come with many caveats to coverage compared to what is available within this bill. This legislation would be a game changer for self-employed trade workers, as our body is our main tool of our craft. If we become injured due to an accident or repetitive motion injury, we cannot work from home. If we are not physically working, we have zero income. This not only affects my household, but it also affects the owners of the building of whom I pay rent to, the distributors I buy products from, and the neighborhood restaurants and coffee shops I frequent daily. Yet I rarely hear legislators speak about that circular economic hit that happens in the community due to the lack of this type of policy. This legislation would provide up to 12 weeks of medical leave and up to 12 weeks of family leave, allowing us time to fully recover versus exacerbating an injury by returning to work prematurely in order to cover living and business expenses. Senate File 2 would relieve many stressors small business owners feel when contending with the fact something like an unhealed fractured wrist could close our doors. I urge the committee to pass File 2. It is good for business, good for Minnesota, and the right thing to do. And side note, thank you so much for passing the Crown Act. It's far overdue. Thank you.
Thank you, Ms. Herskovitz. While Ms. Rogers is preparing to testify, if Christy Hall could come forward and take Ms. Herskovitz's seat. Thank you. Ms. Rogers, please go ahead.
Good afternoon. My name is Caitlin Rogers, and I'm co-owner of Next Day Animations. We make explainer animations, and we have a staff of about 20 folks. I'm also here as a member of Main Street Alliance. So even though we're a small team, we do provide parental leave for our staff. It's essential for us to compete with larger employers, retain our staff, and we need to prevent turnover because it's incredibly expensive for us. In the last year, of our team of 20, 4 folks have had a child, and a 5th person is due in the next couple weeks, any day now, actually. And I want to be happy. I want my first thought to be that I'm delighted for my team, but in reality, this presents a challenge for our business. The last thing that we want is for our employees to choose between work or family. And so far, we have retained everyone on staff, but this investing in parental leave does come at an opportunity cost. We're not able to invest in the growth of our business, and we're not able to invest as fully into raises as we want, which is on everybody's mind this year because of inflation. So frankly, I think we would have been far better off under a universal paid medical leave program where everyone pays in and everyone benefits. Access to up to 12 weeks of medical leave and 12 weeks of family leave would level the playing field for small businesses like ours. Employees shouldn't have to rely on the goodwill of their employers. And as employers, we shouldn't be in charge of providing a social safety net that we as business owners also need to access sometimes. I urge the committee to pass Senate File 2. This will be a critical support for families, communities, and small businesses like ours. Thank you.
Thank you, Ms. Rogers, for your testimony. And while she's leaving the seat, if Ryan Mick could come forward, take the vacant seat now. And Ms. Hall, if you please go ahead and present your testimony. Thank you.
Good afternoon, Chair and members of the committee. My name is Christy Hall, and I'm the Senior Staff Attorney at Gender Justice, a legal and policy advocacy nonprofit dedicated to advancing gender equity through the law. I'm here today to speak in support of paid family medical leave. Paid family medical leave is a critical part of making sure that parents in Minnesota can raise the families that they want and care for their loved ones. Gender Justice supports the bill's inclusive definition of family that honors the diversity of ways that Minnesotans create their families. Respecting chosen family is critical for all people, and particularly for the equality of LGBTQ+ people. And it's important to speak to this committee's jurisdiction. It's important that rights come with the ability to enforce those rights. Rights without remedies may as well not exist. And the ability to enforce those rights is important not just for the employees that need the ability to take advantage of the benefits that have been provided them, but also to employers who it helps create a level playing field and make sure that employers aren't at a competitive disadvantage when they choose to follow the law. Gender Justice represented a woman named Ina Wages a few years back who was fired a day before her one-year anniversary when she would have been eligible to begin taking FMLA leave. Because she was pregnant, she needed that leave. And we were able to successfully argue at the Eighth Circuit that this was an interference with her protected right. And the ability that she had to be able to enforce that right that she had also means that the next employee who comes along, may not have to even go down that route, and may simply have the ability to take the leave that they're entitled to be respected. Thank you, and I urge you to pass SF2.
Thank you, Ms. Hall. Our next testifier will be Ryan Mick. Mr. Mick, go ahead and identify yourself and your association.
Yes, thank you to the chair and members of the committee. My name is Ryan Mick, and I am here on behalf of the Minnesota Employment Law Council. I believe that there are some amendments that will be presented here shortly, and I would like to thank Senator Mann for working with MELC on those. It's been a very constructive conversation, and I think we've come to a good place on some of these issues within the jurisdiction of this committee. In order to clarify the bill and to improve workability for employers and employees alike in several important respects. So again, thank you to Senator Mann for the opportunity to work with her in her office to improve the bill. I'm happy to go through and provide some context to the amendments. I'm happy to take questions, and I defer to the chair and Senator Mann how I could best be useful to the committee.
Thank you. Well, why don't we, before we go there, Senator Mann, do you wish for us to make sure the...
Change now to the amendment that they're getting a draft for.
Would you like to have the amendment distributed at this time, Senator Mann?
No, I think we can continue with testimony and do that afterwards.
Okay. I don't
Mr.
have
Chair.
anyone else on the testifier list.
Oh.
So I know that there is a small change being made to the amendment that was drafted prior to the hearing. Are we getting another written version of it?
Yes.
Good timing. Senator Mann, we have the updated version in writing here. So we're going to go ahead and have that distributed to the members and make it available to the public as well. And I'm going to note for our members in your packet, there is a summary from Senate Counsel identifying the provisions which are within the jurisdiction of the Judiciary Committee. And then there's also a note in there from a presentation that was made at the beginning by Ms. Fitzpatrick, which also covers their jurisdictional provisions. And members, there are quite a few letters and other notes in your packet from submitted by individuals and associations, both in favor of and opposed to the bill. Senator Umu Verbatim, would you move the A51 amendment for us so we have it before us?
Mr. Chair, yes, I'll move the A51 amendment.
All right, the A51 amendment is before the body now. Senator Mann, how would you like to proceed in terms of reviewing the amendment? Do you want to
Thank
have
you, Mr.
council
Chair.
go through it, or do you want to go through it?
Well, the amendment just clarifies the rights and responsibilities of employees and employers as it pertains to this program. I can certainly have our resident lawyers here talk about them.
Oh, yeah, thank you.
Well, why don't we have Ms. Primo walk us through the amendment, and then anything that Mr. Mick would like to add to it, since he was involved in the drafting of the amendment, is welcome to do that, or Ms. Fitzpatrick, and we'll take it that way. Ms. Primo.
Mr. Chair and members, I will walk through the amendment and point out some of the pieces that MELC can help further explain to the committee. So looking at the A51 amendment, lines 1.2 through 1.5 provide technical and clarifying changes. Some of these changes are to the data provisions, and this just clarifies that the data is being exchanged between the two departments, which was the intent of the bill. Lines 1.6 through 1.12 are changes requested by MELC, and line 1.6 to 1.7 included some input from DLI. Line 1.13 through line 2.10 amends the remedies provision of this bill. And this includes changes that were requested by several stakeholders, including MELC, NELA, and NELA. This removes consequential damages. It also reduces the amount of liquidated damages so that it does not include the interest earned on damages. It also provides some clarifying language and technical changes. This section provides a right to a jury trial and provides that that right may not be waived. And remove some language related to class actions that one of the stakeholders felt was confusing. So instead, there's a reference to Rule 23, which is one of the rules of civil procedure that provides for how to get class action certification. And those are the main changes to the remedies section. And the remainder of the amendment, lines 2.11 through 2.20 are changes requested by MELC. And I'm not sure if those ones had input from other stakeholders. Line 2.21 is a technical change. And if there are specific questions, I can help answer them.
We're going to give a moment for our testifiers to take a look through the A51 amendment. If I can get an indication of when they're prepared, I'll hear some input, and then we'll entertain committee discussion. So as a preliminary matter, as they're finishing their review of the A51 amendment, I'm going to note that some of the content of the A51 amendment falls within the primary jurisdiction of the Labor and/or Jobs Committee. Normally, we don't act upon provisions that are related to other committees' jurisdictions. I have, however, received direct guidance from the chairs of those two committees that we can go ahead and make some decisions relating to the provisions in the amendment that's before us. This bill will go on to the Jobs Committee at some point in its future path, and so that committee will have an opportunity to take a look at the work that we have done and decide if they wish to keep it or change it as they wish. With the permission of the chairs of those two committees, we can, and especially if there's stakeholder agreement on the provisions, we can go ahead and adopt them, or do what we wish with the amendment. Now, we have Ms. Fitzpatrick and Mr. Mick at the testifier table. Did either of you want to offer anything, any additional thoughts on the A51 amendment that's before us? And then we'll open it up for committee discussion. Ms. Fitzpatrick?
I'm good.
Nothing to add? Mr. Mick?
No, thank you.
All right. So is it fair for us to conclude that that the A51 amendment does reflect an agreement of at least the organizations represented by Ms. Fitzpatrick and Mr. Mick? Mr. Mick?
Senator Latz, if I may, I think we are making good progress. There are a couple of things that I think will require a little bit of additional work here. And so these are, the amendments as they are listed are positive, but I think there might be a little bit left to do.
Ms. Fitzpatrick?
Chair Latz, I would say ditto. We are, this is good progress. We're continuing the conversations. Look forward to continuing to work on these pieces. Thanks.
All right. So if the pieces that you each believe may need some additional work fall within this committee's jurisdiction, we're going to do that work today in this committee. If they are provisions that fall outside of our jurisdiction, then they can be handled in the Jobs Committee, I suppose. Senator Mann?
Mr. Chair, there is one piece that we think might fall under your jurisdiction. We do have another stakeholder here who's also involved in the conversation. I don't know if he would like to come up to the table also.
That would be Brian Roshi from NELA.
I see another gentleman approaching, so let's just make some room for that, and I guess we'll take input. I don't think the committee is going to spend a lot of time as mediators in this, but we do have to make a decision how we wish to approach this amendment. So, sir, could you go ahead and state and spell your name as well for the record and give us your input?
Yes, absolutely. My name is Brian Rochelle, R-O-C-H-E-L, and I'm here on behalf of Minnesota NELA. That's the Minnesota chapter of the National Employment Lawyers Association.
All right. Go ahead and proceed with your input, please.
So Minnesota NELA was submitting some concerns with respect to clarifying that there's a right to a jury trial. Just having had the opportunity to review Amendment 51, we see that it appears that some language is intended to ensure that there is a right to a jury trial and that that can't be waived, which obviously would be a good thing for Minnesota's workers from our organization's perspective.
I'm sorry, I didn't catch the last part. Could you say that again?
Yeah, that
Be a good thing for
our organization's members and our constituents, which are workers and employees in Minnesota. So we're in favor of the amendment's addition to ensure that there is a right to a jury trial.
Well, so I actually made a note to ask a question about that, so I'll just go ahead and ask the question. I personally haven't seen a provision where a plaintiff is prohibited from waiving a right to a jury trial, at least not, say, pre-employment. I mean, I can understand a ban on a condition of employment that an employee coming in the door without knowing whether they have any claims, and hopefully never will, that they be required to waive a right to a jury trial under any remedies provision they may later take, seek to enforce. But to say that after they decide they have a claim, that they could not choose to waive their jury trial and have a trial in front of a judge, are there any other provisions in state law where that is the case?
Mr. Chair, I'm not aware of any, and that is a very good point. So the language that I'm looking at here in A51 is not the specific language that Minnesota NELA had proposed. I'm looking at it for the first time right now, and that is a fair point. I think the spirit of the rule, at least from Minnesota NELA's perspective, is to ensure that prospectively, and in particular in, say, an employment or pre-employment agreement or application, that right would not be waivable. But the point about whether that could be waivable after an action has been initiated is a good point, and I'm not aware of any analog in the law where that exists.
Is it the desire of Minnesota NELA or of MELC to require a claimant to go through a jury trial if the claimant would prefer to waive the right to a jury trial and have the trial in front of a judge, or to submit their claim to arbitration?
I would say on behalf of Minnesota NELA, Mr. Chair, no, that would not be the intent. Rather, the intent would be just to ensure that this remedies provision is in line with the rules of civil procedure in general, in that parties can choose to waive their right to a jury trial once they have a right to a jury trial, but also to ensure that it's in line with many statutes in Minnesota, including, for example, the Minnesota Human Rights Act, which ensures that a claimant has the right to bring a jury trial, but that point taken, the claimant or the employee or the plaintiff would not be required to pursue their claim in front of a jury rather than a judge if the employee did not choose to do that.
Mr. Mick, is it the position of the MELC the same?
If I understand the comments, Mr. Chair, yes, that's correct. Like you, as we were looking at this for the first time and see that the provision that there cannot be a waiver upon the accrual of a claim is concerning, and it would just lead to very inefficient litigation, and lawyers are engaged for their wisdom in practice, and if they advise the client and the client chooses on both sides to waive that jury trial, that would be the ordinary course, and that would be the proper approach here in MELC's view.
And Ms. Fitzpatrick, did you have any input on this provision? All right, you seem nodding your head no, which I'll state so we have a record. So I'm going to take that as a concurrence along the lines of the comments that we are hearing now. Senator Mann, you're the chief author. What's your view on this?
If parties are in agreement, I am also in agreement, Mr. Chair.
Okay, is there any, let me just ask, just to this point alone, is there any discussion from members of the committee? I'm not seeing any, so I'm going to assume that there's some consensus here at the Senator Limmer.
Mr. Chairman, I was concerned about that language, but it's been a while since we, and as a committee, have talked about civil law judicial procedure and the rights given to plaintiffs and defendants. And I am listening carefully to your concern about it. I almost need to go back and have a primer on civil court procedure of when would we waive that, when we would not. And
I can ask counsel to give us a little primer on that right now, if you wish. The ancillary question comes up whether or not a defendant could insist on a jury trial, even if the plaintiff chose to waive it, which there's an analog, at least in criminal law in that regard, if I remember right. But Ms. Primo, can you give us a little bit of information on current rights under civil procedure to jury trials for claimants?
Mr. Chair and members, this is not going to be an exhaustive and comprehensive review, but there is the right to a jury trial in a civil case is addressed in the rules of civil procedure. and it's available only in certain contexts. The rule states, but I don't have the rule before me right now. I think it's in terms of certain money damages, and perhaps one of the actual litigators may be able to illuminate us on when that specific right is available.
Senator Limmer?
Mr. Chairman, it seems like the parties at the testifying table have had discussions as this bill has progressed. Are these lines a product of negotiation between the parties at the testifying table?
Respectfully, Senator, today is the first that we've seen this edition for MELC.
Okay.
Senator Limmer?
I've asked my question, Mr. Chairman.
Senator Seeberger?
I'm wondering if the intent here was to not make a, not put the plaintiffs in a position where they had to waive a jury trial and sign an arbitration agreement. And I'm wondering if the intent could maybe be addressed by changing the language, something along the lines of an employee, I had it in my head and now I forgot it, but that they can if they want to, but a condition of employment wouldn't be conditioned on them signing an arbitration agreement, something like that. I'm wondering if that's what the intent was here.
Mr. Rochelle?
Mr. Chair and members, I believe that that is an accurate portrayal of the intent. As I'm reading through this again and thinking through it a little bit, I wonder if the concern that Mr. Chair had raised may not actually come to fruition, though, because as I'm reading it, it says that an employee cannot waive their right to a jury trial. And I'm not a constitutional law scholar, but my understanding is that a party may have a right to bring a jury trial. But when a plaintiff initiates a suit, they have the ability to demand a jury. The party does not have to demand a jury at the time of initiating a suit. So for example, if an employee or a plaintiff initiates a lawsuit, they then have to make a demand for a jury trial in addition in their complaint. They can bring that demand subsequently after initiating the complaint, the later point, and the party can ultimately waive or rescind that demand later in the proceedings as well. But you cannot make a proper demand for a jury trial unless you have a right to do so. So this language may actually be exactly right.
I'm going to suggest that we noodle on that topic for a little bit and think about whether we think the language accomplishes the intent. And open up to the committee's discussion any other provisions that are proposed in the amendment. Senator Seeberger.
Thank you, Mr. Chair. I had two concerns looking at subdivision 8, the remedies section, which I believe is under the jurisdiction of this particular committee. The first is on the first page of the amendment, it's beginning at line 1.19, which essentially provides for a plaintiff having the ability to recover double damages should they prevail at trial. And while this does allow a court to reduce the initial award of damages if they find that the offense was not if the employer had reasonable grounds for believing that the act was not a violation. So if the employer was acting innocently and inadvertently violated, it looks like there's some permission for the court to reduce the initial recoverable damages under subsection 1 but we would still result in a double damages award. Is that right?
Mr. Rochelle?
Mr. Chair and members, that appears to be a reasonable reading of this language, which again, I'm looking at for the very first time right now, but that does appear to be an accurate read. This is not language that Minnesota NELA has proposed, and it is not language that Minnesota NELA supports. In fact, Minnesota NELA would have concerns with respect to this language, and at several other points within Amendment 51 as well.
Follow up, Mr. Chair?
Senator Seaborg.
Thank you. I do note that a version of this language is included in the original bill on page 36 at line 36.13. And I'm glad to hear that you share my concerns with regard to this particular double damages language. My other concern is on page 2 of the amendment, starting at line 2.1, with the language stating that a court must, in addition to the judgment, allow the prevailing plaintiff reasonable attorney's fees, reasonable expert witness fees, and other costs incurred by the plaintiff, without giving the court any discretion. Now, in full disclosure, I'm a civil litigation defense attorney, and I tend to adhere to the belief that parties should proceed under the American rule, which is each side bears their own costs. I understand that the intent here is to, or it seems to, give the law a little bit of teeth, but my concern stems from two places. Number one, as a civil litigation defense attorney, this seems entirely inequitable, that the plaintiff, if the plaintiff were to recover, can potentially be awarded damages, double damages, and then pay the costs, the attorney's fees, costs, expert witness fees, which can be substantial. Okay? And then also as a small business owner, I have 2 employees. My business breaks even. I don't get rich off of my business. If I made a mistake and was unsuccessful in court in proving that I had made a mistake, and it was a good faith mistake because it's a new law, and I get hit with damages, double damages, and I have to pay an award of attorney's fees, costs, and expert witness fees, that's going to knock me out of business and probably throw me into personal bankruptcy. So I have concerns from a standpoint of equity as to plaintiffs and defendants, and I have concerns as a small business owner. Now, I'd love to see subsection C go away, and this is also included in the underlying bill. It's the same language. I would love to see subsection C go away and the parties proceed under the American rule. But if the stakeholders are committed to having this language in, then we have to change must to a may and give the court discretion.
Mr. Chair?
I will note for the record, council has done a little bit of checking on this. The Minnesota Human Rights Act has a may in that provision instead of must in terms of prevailing plaintiffs' attorney's fees. Senator Howe.
Thank you, Chair Latson. To that point, is there anything recoverable for a employer if it's an intentional misrepresentation? I mean, besides, the only thing I can find in here, and it's on the amendment 2.17 to 2.19, it looks like they get to terminate the employee, but it doesn't look like they get to recover any of their costs for defending themselves on an intentional misrepresentation filing. So to that point, the scales are definitely tilted one way, and it doesn't look like a balance. Thank you, Mr. Chair.
Senator Mann, any thoughts on how we should approach these issues here? can ask what is the will of the committee with regard to some of these questions. Any further input from the committee?
No, Mr. Chair, we've been having these conversations over the weekend with all the involved parties trying to get to a consensus. I think, and I don't know what the role of the committee has in getting us to those consensus, but we are happy to continue having those conversations.
Senator Seeberger.
I would love to see subpart C stricken from the act in its entirety and the parties proceed under the American rule. However, if it is to stay in, then I would suggest changing must to may on line 2.1.
Mr. Chair and members, Minnesota NELA would have concerns with change.
I want to hear what you have to say, but give us just a moment. Mr. Rochelle, go ahead.
Mr. Chair and members, with all due respect, to speak specifically to omitting section or subdivision C here altogether, the prevailing attorney fee provision is absolutely necessary for any of the people who I or my members represent. Without the ability to recover attorney's fees if you win a suit, almost none of the workers or employees in Minnesota would be able to avail themselves of the benefit of this provision. It would simply be too costly. With respect specifically with the language on must versus may, must is not an uncommon term in the jurisprudence, whether under state or federal law for attorney fee shift provisions. And I want to reiterate that in order for any award to be provided at all, the plaintiff must prevail. So if a plaintiff pursues a suit and loses, there's no right to recover any costs, disbursements, or attorney's fees. This only exists specifically and solely under the condition that somebody brings this lawsuit and wins. And the final point that I want to highlight again is that this language uses reasonable attorney's fees, which has decades of federal and state precedent behind it, which says that courts must interpret the reasonableness. So if a plaintiff's attorney were to come in and say on a certain judgment or award that the attorney's fees is grossly outweighed by what is reasonable, which means what other attorneys in the community charge in terms of rates, what other attorneys in the court would expect in terms of reasonable hours to obtain the degree of success, then the court will issue the award appropriately. So it's Minnesota NELA's perspective that the language as written already has the safeguards built in that the committee or some committee members are concerned about.
Mr. Chair.
Mr. Mick.
As I sit here, I don't recall an employment statute that uses the word must in this context. I'm happy to be corrected if I'm wrong, but I don't recall it. The comment, I believe, from counsel earlier that the MHRA refers to may, and I don't have that in front of me either, but that is a standard that the attorneys in the state are familiar with. It's demonstrated its workability for a considerable period of time, and that would seem to make sense in this context as well.
It appears that the FMLA, so the federal law, uses the word shall, and that this language was pretty much lifted from the FMLA, as was noted in some earlier testimony, with the exception of changing shall to must. And the Minnesota Human Rights Act uses the term may. So our analogs are mixed on this. And I guess we should maybe get a sense of the chief author wants to weigh in on this, or the committee can entertain, if Senator Seeberger has a motion, we can address it in that way. Senator Mann, did you want to give us any input on this point right now, or just leave it up to the committee?
I would like to hear from Senator Seeberger, Mr. Chair.
Senator Seeberger.
Thank you,
seem to have
Mr.
the
Chair.
two employment lawyers here have somewhat divergent, employment defense lawyers at the table seem to have somewhat divergent approaches to this as well. So, Senator Seeberger.
Thank you, Mr. Chair. I would move to amend the language on line 2.1 of Amendment A51 to change the word must to the word may.
Senator Seeberger moves to amend line 2.1 to delete the word must and insert in its place the word may. Is there any discussion on the amendment? Seeing none, all those in favor of the amendment say aye. Aye. All opposed? Motion prevails, the amendment's adopted. Is there any further discussion on the A51 amendment? Senator Seeberger.
Then can we return to page 1 of the amendment, lines 1.19 through 1.25, the double damages award? It sounds to me like some of the stakeholders had concerns with this language also. And I would suggest that since it doesn't sound like it's something that the parties have agreed to, and since I'm hearing concern from the employment attorney bar as well, I would suggest that this language be stricken. And in fact, I would make that motion.
Well, Senator Seeberger moves to on line A50, or the amendment A51 to delete lines 1.19 to 1.25 and make any conforming changes that are necessary. Yes, we'll have counsel read the amendment, the proposed amendment.
Of the A51, page 1, delete lines 19 to 24. Page 1, line 25, delete everything before and. Oh. And renumber the clauses in sequence.
So I have a question for Ms. Fitzpatrick. As I understand it, this language was also taken directly from the FMLA. Is that correct, Ms. Fitzpatrick? Can you just come up to the mic and give your response, please? I don't want
Chair
to be
Latz.
responsible for inaccurately stating for the record a head nod one way or
Yes,
another.
Chair Latz, members of the committee, that's my understanding. That language was taken from FMLA.
Counsel, is that your understanding as well, Ms. Primo?
Mr. Chair and members, yes, the language is almost identical to the FMLA.
Okay, now, as a part of the amendment we have before us, as it was described when we first brought it up, there was originally a consequential damages provision in the amendment, or in the bill, that was removed. And there was also, let me ask that, is that correct?
Yes, Mr. Chair.
Mr. Mick? Okay. And could you tell us a little more explicitly what that means?
Certainly. There's no, I think, reasonable dispute that an appropriate remedy, Mr. Chair, under this bill is for recovery of wages and benefits lost. The consequential damages provision stated that if there was a debate over additional monetary losses that might have been caused by a denial of rights or benefits, that could be potentially recovered under this bill as well. And it was MBLC's recommendation that come out. Consequential damages are rarely, if ever, found in statutory schemes like this, and the uncertainty of the sorts and nature and types of monetary losses other than wages and benefits that might be pulled into litigation in the event of a dispute over this is really unpredictable and potentially catastrophic for the employer. And so for that reason, and consistent with other statutes, MBLC had recommended that the consequential damages provision come out.
And there was also a provision that contained sort of a double interest award in the damages description in the original bill that is, we are told, has been removed in this proposed amendment. Is that correct, Mr. Mick?
Yes, Mr. Chair, it is.
Could you explain that, please?
As originally drafted, and again, this is consistent with Minnesota law that a plaintiff employee who is successful in a case like this, if they are awarded damages, they may also receive interest on the damages that were awarded from the court in the remedial phase of litigation. As originally drafted, the language purported to double interest, and then MLC's position would be that it allowed interest to then accrued on the doubled interest pursuant to the liquidated damages provision. I do believe that has come out based on a quick review of the language that has been presented here this morning, this afternoon, excuse me.
And then there's been some concern raised about the provision relating to liquidated damages. Could I get perhaps Ms. Fitzpatrick and Mr. Mick or Mr. Rochelle to explain sort of what the implications are of that provision and the purpose of that provision? Mr. Rochelle, you can go ahead while you're at the table, and then we'll have Ms. Fitzpatrick, come on and have a seat. That's fine.
Mr. Chair, I'm happy to start while she's coming to the table.
Mr. Mick.
The liquidated damages provision is a penalty. It doubles the amount of damages awarded as a penalty. So in terms of the context, and it's simply that.
And does the amendment make that award mandatory or optional for either a jury or a judge making the decision to award?
Mr. Chair, we're all reading this together. Mr. Chair, it appears to be mandatory in the first instance as drafted, except that the court may, in its discretion, may reduce that.
Mr. Mick, if I'm reading this right on line 22, that reduction or elimination of it could be if the court were satisfied that the act or omission which violated the provisions was in good faith, or that the employer had reasonable grounds for believing it was not a violation of provisions of the section. Is that, are you reading it the same way as I am? So basically, it would be a sort of a mandatory penalty unless the employer was acting in good faith or had reasonable grounds to believe there was no violation?
That appears to be correct, Mr. Chair.
Is that kind of the inverse of saying if there appeared to be sort of a reckless or intentional violation that they're subject, which is kind of a default determination, one could say, unless the judge were convinced otherwise? Am I understanding that correctly, or is that not a fair way to describe it?
Mr. Chair, if I may, it's close, except to the extent that the default would be that it would be the burden on the employer to show reasonableness. If I understood the chair correctly, it would be different to say that the plaintiff would have to prove recklessness in order to recover liquidated damages.
I see what you're saying. And this is language that was already in the FMLA, as I understand. Is that correct?
Mr. Chair,
Ms.
members of the
Fitzpatrick, and then we'll go to Senator
Yeah,
Seaver.
just the rationale, again, as we were writing this bill, was to try to rely on, not reinvent wheels, and to rely on these types of, the FMLA in the case of, and all the case law and all of the background that has gone into developing the FMLA and all the case law since then. So just as a rationale from the advocate's point of view and our work on this bill, we were trying, wherever possible, to build on those existing ways employers are used to, addressing these kinds of leaves. And so that's all I can say on that point. We were trying to do, that was the goal.
Okay, and the purpose of that provision in the FMLA would be what? To incentivize employers to be extra careful about complying with the statutory requirements?
Chair Latz and members, that's
Mr.
exactly
Rochelle.
right. The purpose of it is to ensure that employers have a motivation to maintain lawful compliance. Without this sort of added requirement, you have the situation that so many people who contact me in our office and my members' offices on a regular basis, including, I'll give you an example of one last week, terminated, per se violation of the Family Medical Leave Act, had to go out on leave, didn't return back to work, found another job right away. That's great. Almost all the people who reach out to us are hardworking people who want to continue to earn a living. The wage loss damages in that scenario, close to $0. The penalty for not complying with the law, if we don't bring a claim, nothing. There's no wage loss under the Family Medical Leave Act that we can bring. So the double damages provision is just a small step to ensure that employers have that added incentive to ensure that there is compliance. I'll also note that when counsel was talking about the consequential damages provision, I think counsel said that it was rarely, if ever, found provision. In stark contrast, a liquidated damages provision is very common. It exists in the Family Medical Leave Act. It exists in the Age Discrimination in Employment Act. It exists in the Fair Labor Standards Act. It exists in many other statutes. And it has not yet, as far as I or my members are aware, have served to make it so that employers are unable to comply with the law or unable to stay in business. I'll also note that the exception that exists here in subparagraph 1 that essentially says that if an employer acts in good faith or otherwise did not know that it was violating the law, that a court or a jury could then reduce the amount of liquidated damages, does not exist in the Family Medical Leave Act. So these other federal statutes that have liquidated damages analogs do not have that carve-out there. And that's something that Minnesota NELA is actually concerned about, because that carve-out could swallow the entire provision. If you read it to say that an employer or somebody acting under the color of their employment, so a supervisor or somebody who violates this statute, could essentially say, well, I wasn't aware or I didn't really bother to follow the medical paperwork, so how was I supposed to know that this person had a qualifying condition or something along those lines, would then no longer be subject to the liquidated damages provision, which again is very different from what exists under the law today in the Family Medical Leave Act.
And as I understand it, the Minnesota Human Rights Act does have a provision for up to trebling of damages for basically the same purpose, to provide a consequence, even if the wage damages are very low.
Chair Latz, yes, it does. The Minnesota Human Rights Act has a treble or triple damages provision.
All right. And Mr. Mick, what is the position of the MELC with regard to, maybe we should clarify for the record here, NELA, N-E-L-A, is an organization of lawyers that represent claimants or plaintiffs, employees in these kinds of matters, or employment-related matters, and the MELC is an organization of lawyers that predominantly represent employers in these kinds of claims. Am I accurate about that?
Quite.
Okay.
Mr. Chair.
Just in case it wasn't clear to whoever's reviewing the record, you know, the viewpoints of the testifiers here. Mr. Mick, does the MELC have a position with regard to this provision, including the carve-out?
No, Mr. Chair.
Senator Seeberger.
Thank you, Mr. Chair. In addition to the inequity that I find in just having this liquidated damages or double damages provision in the first place, I'm troubled by the language in line 1.21, which requires an employer, now the defendant, to prove to the satisfaction of the court that the act or omission was in good faith or the employer had reasonable grounds for believing that the act or omission was not a violation. And I don't know what level of proof that requires, but backing up, in a civil lawsuit, the plaintiff has the burden of proof by a preponderance of evidence, and now we're shifting the burden to an employer, the defendant, to prove something else. And as to the satisfaction of the court, is that by a preponderance of the evidence? Is that a clear and convincing evidence? Is that beyond a reasonable doubt, or is that some other standard? Does that vary from court to court? So you can be in Hennepin County District Court and proving it by preponderance of the evidence, and you can be in Washington County District Court proving it by beyond a reasonable doubt. I don't think this language is clear. I don't think it provides enough guidance. I think it's inequitable. I don't like it. That's why I would like it stricken.
Any of the testifiers have an answer to Senator Seeberger's questions about burden of proof and burden shifting?
Mr. Chair, no answer. It is a fair point that the burden of proof is not specified. Satisfaction of the court would be up to the discretion of the judicial officer.
I would assume the default burden of proof in a civil action is preponderance of the evidence unless specified otherwise. Wouldn't that ordinarily be the case in a civil action? Mr. Mick or Mr. Rochelle?
That's my understanding, Mr. Chair.
Mr. Chair, I won't venture a guess, but you may be right.
I mean, my understanding in civil statutes where I've seen, if a clear and convincing burden of proof is intended, it's laid out in statute explicitly, and there are some of those. And the beyond a reasonable doubt standard is only found in criminal law as far as I'm aware. Senator Cruin.
Thank you, Mr. Chair. To speak on this latest point raised by Senator Seeberger and yourself, Mr. Chair, I think typically, yeah, if it doesn't specifically say, it would be preponderance of the evidence, but most of them don't also add to the satisfaction of the court afterwards, and that's where the ambiguity comes into Senator Seeberger's point. What does that mean? And that's not a term that I've seen. I mean, maybe it's out there somewhere, but it's not typical, and I think it does bring confusion into burden of proof. But that's my comment on the latest issue. I guess to back up when I'm considering this proposed amendment to the amendment, I just want to make sure I'm understanding this correctly. This private right of action in state or federal court, I guess, that gives rise to what we're talking about today, is that in addition to civil penalties that the commissioner can levy as well, which we were talking about under SF 34, where if that were to pass would be up to $10,000 per violation. Does that bring, do a violation of this bring that into account? So we're talking about civil penalties by the commissioner plus a private right of action that potentially has double damages and attorney's fees. Am I understanding that correctly?
Do either of our testifiers wish to answer the question?
Mr. Chair, I'm not certain that all the testifiers heard the question. If the question is the private right of action in addition to civil penalties, I believe the answer is yes.
Senator Cruin.
Okay, well, I guess that makes my decision quite easy on the proposed amendment to the amendment. I mean, this is, when you add all these things up, this is just an incredibly oppressive, punitive to employers here. You're talking civil penalties, which again, if SF 34 passes, I know that's not specifically in this bill, but if it passes, it'll have an effect on this bill, which will increase the civil penalty from $1,000 per employee per occurrence to up to $10,000 per employee per occurrence. And we're adding a private right of action on here, double damages, attorney's fees. I mean, where does it end? I mean, this is just incredibly impunitive to the employer. So I'm in favor of the proposed amendment to the amendment.
Ms. Primo's getting a little clarity, doing a little research here, Senator Croon, in response to your comments, so we have the facts clear on that. But I will note, we did look up the FMLA, and the carve-out that is in here, lines 20 to 25, is also taken directly out of the FMLA, which includes the standard of to the satisfaction of the court. So for whatever that's worth, this is language that's already in federal law that applies to these circumstances. So if this were to remain in the bill, it would mimic the federal law in that regard rather than creating a different, potentially different standard or burden of proof. In response to the question about the application of Senate File 34, we're trying to get that nailed down for you, Senator Croon. While council is looking through that, is there any other discussion on this point right now? The amendment that we have proposed by Senator Seeberger before us. Senator Mann, you're the chief author of the bill. What is your preference with regard to this proposed amendment?
Thank you, Mr. Chair. I would accept the amendment to the amendment.
Ms. Primo, in response to Senator Croon's points.
Mr. Chair and members, so yes, Senate File 34 included an increase in penalties from $1,000 to $10,000 per repeat violation. And that subdivision cited back to subdivision 4 of that same statute. And in this bill, subdivision 4 of 177.27 is being amended to include this chapter. So I'll take you to page 2, line 1, section 2. So if they are both passed, it would mean that a repeat violation of what under this chapter would trigger that higher penalty.
Senator Croon, any follow-up on that?
Thank you, Mr. Chair, and thank you to Senate Council. That was my understanding as well, and that's, I guess, why I'm particularly concerned. You know, this goes beyond the amendment to the amendment, so I can hold some of these comments for later. And if the author is accepting this amendment to the amendment, it's kind of a moot point. And to the standard of proof, I didn't know that was in the FMLA and federal court standards. Nevertheless, I still think it's confusing and not a good way to draft law, but that's just my opinion on that.
A bunch of lawyers in a room, we all have different opinions on how the best way is to draft a law, right? I will tell members of the committee, for what it's worth, I'm very concerned about the prospect of removing this If, for exactly the reason that Mr. Rochelle described, if someone finds a job promptly and there are very little lost wages as potential damages, removing this provision would mean that there would be basically no financial consequence to an employer that violated the law. You know, many in the room already know this, but I'll just state, I do practice in the field, mostly representing employees in claims under the Human Rights Act. So that's the vantage point I bring to this as well. But I also try to bring a balanced approach to writing the statutes, kind of independent of the legal work that I do. We all come to the table with our own backgrounds and experiences as well. We have some on this committee that have expertise in real estate law, and others have expertise in family law, and we come by our expertise, you know, by our own work. But stepping back as much as I can from the approach, I guess I would want the playing field to remain level. And if I can tell you this, if an employee were to call Mr. Rochelle and say, geez, I just lost my job after 5 weeks of being on leave when I really needed 8 on my doctor's recommendation. But as soon as the doctor gave me the green light to go back to work, I found another job. In fact, while I was on bed rest or recovering from my surgery, I spent that time online looking for a job, and I had one ready to go as soon as the doctor gave me the clearance to go back to work. So there almost no wage losses. No plaintiff's attorney is going to take that case on, certainly not on a contingent fee basis. There will never even be a claim. And there'll be absolutely no responsibility assigned to the employer for violating that employee's rights. I mean, the private right of action will be worth 0. Because if there are no damages to recover, there's no fee out of which a contingent fee could be paid to an attorney to do the legal work, which is itself risky because a lot of claims don't recover any damages at all or recover a lot less than maybe enough to cover the amount of work that's involved in pursuing these claims, which can be substantial if it goes through the full litigation process. So without this provision, there seems to me in many cases there will be little to no financial incentive for an employer to comply with the law other than the goodwill, maintaining the goodwill of their employees. And on the contrary, it would almost be a green light in a tight job market especially to take their chances and, you know, terminate the employee and see what happens. So I'm really concerned about this, and I recognize the chief author is accepting it as a friendly amendment, and I rarely do this, but I'm still going to oppose the amendment. Senator Seeberger, to your amendment.
Thank you, Mr. Chair. In your example, if there are little to no damages recovered, then doubling 0 is still 0. So leaving the liquidated damages provision in there would not have an effect of creating damages where there are none to begin with. In addition, if a case were to be litigated and there were very little damages to be found in terms of, let's say, wage loss, using your example because the employee did what they were supposed to do and mitigated their damages and found another job, that plaintiff, let's say they prevailed, still may be entitled to attorney's fees, reasonable expert witness fees, and the costs that they incurred. In my experience as a civil litigation defense attorney, having dealt with provisions like this with plaintiffs' attorneys who are under a contingent fee agreement, the recoverable attorney's fees are rarely what is paid, actually paid under that contingent fee agreement. Instead, the plaintiff's attorney will calculate the number of hours worked on the case, assign an hourly rate to that, and that becomes the attorney's fee award. And I will say that in many times that attorney's fee award does not match whatever would ordinarily be paid to that attorney. And as a civil litigation defense attorney who makes a fraction of what the market rate is, it's generally 2 to 3 to 4 times higher than what I actually earned on the case. So there are protections built in for a plaintiff. There are teeth in this without the liquidated damages provision. And again, leaving it in only doubles whatever the damages would be. So if there's no damages, I mean, you're doubling zero. I still don't like it. Thank you.
And I will note that I've been, just so I'm fair and balanced in what I have to say, Senator Howe has pointed out and council has also identified for me the fact that there is still authority on the part of the commissioner to take administrative action where a violation were to be determined. Senator Kroon.
Thank you, Mr. Chair. And yeah, I was going to point out in just response to the comment that there's no financial repercussions to the employer, I was just going to point that out. There's still the civil penalties, so the employer is still going to pay dearly. Number two, to Senator Seeberger's point, it's not the actual damages or even the doubling of the actual damages that's going to have plaintiffs' attorneys want to take these cases. It's going to be the attorney's fee provision. There's going to be plenty of lawyers out there that are going to take these cases, even if the actual damages aren't very much with that attorney fee provision in there. So I think there's still going to be plenty of financial repercussions against employers, plus there's still going to be plenty of attorneys out there that are going to take these cases, even if we take out this section under Senator Seeberger's amendment to the amendment. So I'm in favor of it. Thank you.
Well, I'll just note that the attorney's fees have to be reasonable, and a judge would make that determination. So an attorney who got a $10,000 damage award is unlikely to be given a six-figure attorney's fee award unless there's something unusual going on in the case. But that's all a certain amount of speculation because every case turns on its own facts and however the judge and the parties approach it. Is there any further discussion on the proposed amendment? All those in favor say aye. Aye. Opposed? No. No. Motion prevails. All right, the amendment's adopted. What's that? Okay.
Mr. Chair, can I call division?
Senator Umu-Verbatim?
Can I call division, Mr. Chair?
You can.
Division.
All right, division has been called. All those in favor of Senator Seeberger's amendment, please raise your hand. Let me lower your hands. All those opposed, raise your hand. The chair is corrected. There being 5 in favor and 5 opposed. On a tie vote, the motion does not prevail. The amendment is not adopted. So members, we are now back on the A51 amendment as already amended otherwise. Is there any further discussion on the amendment? Senator Mann, I want to return to little bit of the earlier conversation that was raised about the language on line 21, taken from the FMLA, that the satisfaction of the court. There was some question about whether that language is ambiguous and whether it might make some sense to specify the burden of proof to provide clarity on that. I'm just raising the question, if we were to go and provide some clarity on that, is there a desire, since it was a point of discussion, is there a desire to change that in any way or to leave it as is? I don't know if the chief author has an opinion on that or any other members of the committee have an opinion on that. All right, I don't see anyone. I'm sorry. Senator Mann?
Mr. Chair, can I have one of our lawyers speak to that?
Either one.
Mr. Chair and members,
Rochelle.
it may make sense to add preponderance of the evidence into the statute for clarity. My understanding is that would be agreeable.
Senator Mann, what is your position on that proposal? There's not an amendment yet, so someone on the committee would have to decide if that were something they'd like to do, but I just brought up the point for clarification. Senator Mann?
I think it's a good proposal, Mr. Chair, and provides clarification.
Is there any members of the committee want to have any discussion on that or offer an amendment? Not seeing any. Senator Kroon? I'm not soliciting anything. I'm just trying to get the committee's sense of this. So.
Thank you, Mr. Chair. If I'm understanding you correctly, you're wondering what our thoughts are relating to line 1.21, the language proves to the satisfaction of the court, and whether or not we want to change that to proves by a preponderance of the evidence. Am I understanding that correctly?
That's what I'm describing. So it would be clear what the employer's burden of proof is to establish their good faith or reasonable grounds and qualify for the carve-out to the liquidated damages provision.
Okay, well, I think I can make that an oral amendment. Strike on lines 1.21, strike to the satisfaction of the court and replace it by a preponderance of the evidence.
We're going to ask counsel to go ahead and read that back. Ms. Primo.
Mr. Chair and members, page 1, line 21, delete the satisfaction of. After court, insert by a preponderance of evidence. And I can read that again. If it would
Please
help.
go ahead and then read the whole sentence as
Miss-
the part of the sentence that it would apply to.
Mr. Chair and members, page 1, line 21, delete the satisfaction of. After court, insert by a preponderance of the evidence. And the whole line would read, proves to the court by a preponderance of evidence that the act or omission.
Senator Kroon?
Yes, I'll make that my oral amendment.
All right, is there any discussion? Senator Seeberger?
So would this be, when it says proves to the court, would this be determination we made post-trial, or would this be a jury determination? If we're talking about shifting the burdens and now the defendant has to prove something in a plaintiff's case.
Senator Kroon? I can offer my opinion, but we got a lot of lawyers here, so. Senator Kroon.
Thank you, Mr. Chair. I guess that's when I originally did the oral amendment, that's why I took out to the satisfaction of the court, I guess. It could just say proves by a preponderance of the evidence, and that way it could be within the purview of the jury in the initial case. I guess I don't see the harm in doing it that way. because otherwise it would be specifically to the court to make that determination. So I guess I'm speaking against my own amendment now, but.
All in favor? All right, well, I guess we should get some clarity from the proponent of the amendment, what you would like your amendment to contain, and then we can decide whether we like it.
Thank you, Mr. Chair. I'd like to go back to the way I originally said it, which would be striking to the satisfaction of the court and replacing it with by a preponderance of the evidence. I think that would clear up Senator Seeberger's concern. Unless there's another issue that Senate Council thinks is problematic.
Senator Seeberger, does that meet your concerns, as Senator Kroon suggested?
It does help clarify it, yes, thank you, Mr. Chair. I still don't like the burden shifting. I think it would create unworkable scenarios and a lot of confusion. Thank you.
Senator Limmer.
Just as a review, preponderance of evidence, is that a high standard or a low standard for evidentiary consideration?
More likely than not, 50% plus whatever fraction of an increment.
Plus .001. So I would assume
Senator
that that's the lowest evidentiary standard in order to come to a conclusion, correct?
Senator Limmer, I would agree with that.
All right.
Senator Kroon.
Just thought I'd review that.
Thank you, Mr. Chair. I actually agree with Senator Seeberger. I would prefer there not to be any burden shifting, and I'd prefer that whole subdivision 3 to be stricken, but we've already tried that and it failed. So I'm just trying to make it a little bit better given the will of this committee, and that's, I guess, the purpose of my amendment.
Chief Author, Senator Mann. Your
Mr.
position
Chair.
on the proposed amendment.
So all the parties at the table are okay with the amendment? That's all I got.
All right, any further discussion on the amendment? Senator Carlson. Ms. Primo, could you reread the amendment, please?
Mr. Chair and members, page 1, line 21, delete to the satisfaction of the court, insert by a preponderance of the evidence.
Is there any further discussion on Senator Kroon's amendment? All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Is there any further discussion on the A51 amendment as amended? I'm not seeing any further discussion. Senator Mann, any further thoughts on the A51 amendment as amended? All right, on Senator Uma Verbaten's motion to adopt the A51 amendment as amended, all those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Now, members, we are on Senate File 2 as amended. Is there any further discussion on that? Senator Limmer.
Oh, I'm sorry. I'd like to introduce the A40 amendment.
Council will distribute the A40 amendment. It appears that all members have now received a copy of the A40 amendment. Senator Limmer, please describe your amendment.
Thank you, Mr. President, or Mr. Chairman. The A40 amendment is an amendment that has been brought to my attention by the Minnesota Catholic Conference. The language here, the first lines 2 through 4 are technical corrections if passed, but the real substance is found on lines 1.5 to the end of 111. In front of you, there has been passed a letter from that Catholic Conference asking for recognition of an allowance similar to what we have in unemployment insurance statutes in Minnesota state law. This is a reference for an exception for faith-based organizations, that they be excluded from this particular provision of law. And there's reasons why. These organizations are not your typical employer. They're ones that are based oftentimes on volunteer work or very low income standards. They do it more for the cause than they do for a job. And it's harder to swap out employees in a regard like this. Many are limited money as income, and it's very difficult sometimes or unpredictable in order to find that swap in employees. And they're basically asking us to recognize flexibility. If not, this new provision in law may cause limitations to other benefits, employee benefits that may be involved, may even include their contributions as an employer to their health care, or compromise programs that might be exercised in a greater community and a broad outreach to those communities in need. Many of these particular churches, houses of worship, are very involved in their community. They provide oftentimes services or food or I think you can think of just about anything, clothing, food, basic sustenance. Some churches offer job training for members of their society, and they're only asking for similar allowance as is found in the unemployment insurance. The language that we have before us is taken from the example in the unemployment insurance section of law. And I ask the committee to consider that.
So, Senator Limmer, not to the merits of the amendment, but I'm a bit concerned that the question of which employers ought to be covered by this bill is really a substantive question outside the jurisdiction of the Judiciary Committee. While a change like this may have some ancillary impact on some of our jurisdictional questions because it affects definitions and so on, or remedies as they might be applied to certain employers, it just seems to me it's more of a substantive question for the Jobs Committee or a Labor Committee to evaluate rather than a Judiciary Committee. Now, as a former chair of the committee, I guess, what are your thoughts on that?
Mr. Chairman,
Senator Limmer.
maybe you could enlighten me. Did this bill come from the Jobs Committee already, or is it going to the Jobs Committee?
Senator Limmer, it was already heard by the Labor Committee. I believe it's already been heard by the Jobs Committee, but it's also going to be going back to the Jobs Committee.
All right.
Is that correct, Senator Mann?
Correct, Mr. Chair.
Senator Limmer?
I understand. Knowing that, Mr. Chairman, I know the difficulty as a former chair that this particular amendment may cause. So I'll withdraw the amendment, Mr. Chair. Thank you.
Senator Limmer withdraws the A40 amendment. Is there any further discussion on Senate File 2 as amended? Senator Howe.
Thank you, Mr. Chair. And I just got a question on page 62, lines 1.7 to, or 62.17 to 62.13. And I just want to get a feeling for how this affects independent contractors because, and how it is applied, because I'm an independent contractor and I got independent contractors working for me, and I contract with cities. Who's the employer in this situation? And how is it applied?
Senator Howe, I believe in the definitions section, the independent contractors are explicitly exempted from the coverage of this bill. I'm just going to find it for you. Yeah, on page 9, line 9.22, covered employment does not include an independent contractor. I don't know if that answers your question.
It does not, because here on line 62.17, each employer shall provide to the independent contractor whom it contracts at the time the contract is made. So the independent contractor is involved here. I just want to know if am I, as an independent contractor who has independent contractors working for me, am I the employer, or is the employer the city whom I, as a business, contract with? Who has to provide this notice? That's what I'm trying to get to. And just for clarification, I'm just trying to figure out who is it? I understand what you said. I read that definition too, but I'm just confused as how this is then applied. Because if you screw that up, somebody's going to be paying a fine in section 62.23 to 62.27. So I'm just trying to figure out for who's the employer, who's the independent contractor, and how that works. That's what I'm trying to figure out, and how that is applied in a situation much like mine, where I'm an independent contractor to the city. I have independent contractors contracted with me. How does that notice flow down? Because the independent contractor has an opportunity to participate in this if they so choose. So it looks to me like that notice has to go from the employer to the independent contractor. Where does it start? Because who's the employer that has to apply and give notice to the independent contractor? Who is that?
Ms. Fitzpatrick, can you answer that question?
Chair Latz, Senator, I guess the intent here was that this would be a mechanism for independent contractors to be made apprised of this opportunity to opt into the program. I would imagine the employer definition here would refer back to employer definitions earlier in the bill. So I am not entirely sure that an independent contractor with an independent contractor would be covered under that definition, but could defer again, and maybe this is something to be covered when we go back to workforce.
Senator Howe.
Well, the reason I bring it up is because we just amended with this amendment the subdivision to section, but I just want to make sure when this thing comes down that if I don't get, because I agree with the chair that in the definition of employer, independent contractors excluded in the bill, except for now it comes back in this section. So I guess we got to figure it out somewhere, and because we amended it in this committee, I thought it was important that we have clarification in the committee on exactly what we're applying and where.
Ms. Primo, can you explain the amendment that was just made to this section, please?
Yes, Mr. Chair and members. First, we can start with the A51. The amendment that's being referred to is at page 2, line 21 of the A51. And then turning to the underlying bill, as Senator Howe explained, at line 62.23, subdivision is changed to section, and that is because there are no subdivisions in this section, and so that would be confusing, and therefore it's changed to section because there's just one section that governs all of this. It's more of a technical change to make it clear that it's the entire section that's being referred to and that there's not like a missing subdivision.
So it was a drafting correction, Senator Howe. I think it's a fair question, Senator Howe, but it sounds like the Jobs Committee might be the place to sort that question out. Is there any other discussion on Senate File 2 as amended? Senator Kroon.
Thank you, Mr. Chair. I just have a few questions about how this would work procedurally. And I guess I'm starting on page 29 with the determination by the commissioner. And it seems like, I guess my question on the initial determination by the commissioner, it just says the commissioner must determine any issue of ineligibility raised by the information required from an applicant. Does that mean that an employer can play no role in the eligibility determination by the commissioner?
Ms. Fitzpatrick.
Chair Latz, Senator Klein, Kroon. The process is that the applicant applies to the Department of Employment and Economic Development. The department is relying on wage detail that's been submitted by employers through this act, but it's very similar to UI, to determine the eligibility based on earnings. Then applicants also submit their certifications. There's a series of certifications laid out in the bill depending on the type of leave. That certification is submitted to the Department of Employment and Economic Development. As I understand it, at each stage, the determination of whether those the wage credits have been met, the employer receives and the applicant receives a notification that the person has applied and been deemed eligible based on their wages, and then there's a secondary level of approval and notification based on the underlying condition that qualifies the person for the benefit. So this is kind of two parts to that. And at both stages, the employer is notified, but the employer isn't involved in determining whether the the event is eligible under the law or the program.
Thank you, Mr. Chair. Can you point me, maybe I'm missing it here, but can you point me to where it says the employer gets notification before the eligibility determination is made?
I believe it's under the establishment of a benefit account, but I'm trying to find the rest, that piece. So, so it says on line 21.16, so that first stage, a determination of a benefit account, is where they're checking to see that the employee or the applicant meets the wage requirements and some other pieces just that underlying, are they eligible based on their earnings? And it requires on 21.16 that the determination of a benefit account is sent to the applicant and all base period employers by mail or electronic transmission.
Senator Kroon.
Excuse me, and then just to clarify on line
Fitzpatrick.
28.22, that's when the second notification occurs.
Senator Kroon.
Thank you, Mr. Chair. On 28.22, it says upon a determination that an applicant is entitled to benefits. So wouldn't the decision have already been made by then?
So there,
Ms.
again,
Fitzpatrick.
sorry, Chair Latz, Senator Kroon, there's sort of two levels of approval that occur. The first level is just to determine whether the applicant has met the wage, so this is an earned benefit. So the first stage of proof is, has that applicant met the requirements of the required earnings threshold. So that's the first step. Then there's a second step where the applicant is submitting their certification materials that determine whether, how long and what, excuse me, at that first stage, they're also, is my understanding, and there are people from DEED here who could speak to this, they're also determining what level of wage replacement the person might be eligible for. That is also based on the wage detail. So those types of things are decided at that first level. The second level is whether the event that would qualify them for benefits and leave under the bill, whether that's those certifications from a medical professional or others, depending. So again, there's a sort of two levels of notification and two levels of kind of approval that occur under this structure.
Senator Kroon.
Thank you, Mr. Chair. I guess I'm trying to get at that second level, I think, as you describe it. What if an employer has information that would suggest ineligibility? Would the employer have an opportunity at that stage to participate in the process to bring that evidence and those facts to the commissioner?
Ms. Fitzpatrick.
Chair Latz, Senator Kroon, there are folks from DEED here, but my understanding is that both of those stages, an employer has the ability to bring forward, once they're notified, to bring forward additional information that might challenge the, again, each stage of that process.
Senator Kroon.
Thank you, Mr. Chair. I guess I'm not seeing that in the language of the bill. And I hope if that's the intent of the author, then that should be specifically written into the bill. I see it on the appeal process, but I don't see it in terms of the initial eligibility. And my next question would be, I see in the bill that the employee has a right to appeal, but I don't see where the employer has a right to an appeal. So does this allow for an employer to appeal the eligibility determination?
Do we have a testifier at the table who can answer the question?
Oh.
Go ahead and identify yourself for the record.
Thanks, Mr. Chair. I was waiting. I didn't want to interrupt.
Sorry, go ahead.
My name's Evan Rowe. I'm Deputy Commissioner at the Department of Employment and Economic Development. My laptop battery has met its match in the Judiciary Committee today. I think generally speaking, so I'm still pulling up the language, but I think perhaps one thing to your question, Senator Kroon, is the difference here is that thanks. Ultimately here you're talking about a determination of a question of medical evidence, right? And I think that that's what the bill largely contemplates, is that there would be evidence submitted from a physician or from in that regard, which would be the primary method through which the department could make a determination on an issue of eligibility. Obviously, if there were concerns around misrepresentation or things like that, an employer could certainly raise those to the department's attention, but we wouldn't expect an employer to have to submit evidence on every single claim, because that wouldn't inherently be necessary.
Senator Kroon, counsel has found a line here on 30.15, request for reconsideration, indicating that any party may file a request for reconsideration, asking the judge to reconsider that, and then also on line 30.19, any party may appeal to the Court of Appeals. Senator Kroon.
Thank you, Mr. Chair. A couple things. I'm sorry, I don't remember your name again, Mr.
Oh, Evan Rowe.
Mr. Rowe. I guess I'm not suggesting that the employer would, as a matter of course, submit information at the eligibility determination phase. I'm looking for the opportunity that the employer may submit that in the appropriate case. I know it wouldn't be every case. That wouldn't make sense. We're talking about medical determinations, but I can envision a case where an employer might have evidence or information that would go contrary to some of those things that the employer may be submitting to the commissioner. And it perhaps is the commissioner's practice to accept those things from the employers in those situations, but I don't see anything in the actual bill about it, and that's why I'm raising that point. And then my second point would be to Senate Counsel on lines 30.15, 30.17, a request for reconsideration. That's after already an eligibility determination is made. I'm talking about at the point before an eligibility determination is made, and then the right to appeal that. And this is talking about appealing the benefit judge's decision. So as I see it, we have the determination that's made by the commissioner on eligibility. Then I see that the employee can appeal that to a benefit judge. And then perhaps an employer could request reconsideration after that decision has been made. But what I don't see is for the opportunity for an employer to appeal the eligibility determination to a benefit judge. And maybe I'm missing it, but I'm not seeing that in there.
Mr. Rowe. On the bill, line 29.12, I think that's where Senator Kroon may be looking. It provides for the applicant the ability to appeal. If that word applicant were changed to either party, is that something that would work? Would it accomplish what Senator Kroon is attempting to allow, at least in terms of the appeal? Or is there something more? Senator Kroon, are you looking for some other provision that explicitly allows the employer to submit evidence before the determination is made? It sounds like that's the practice either way. Senator Kroon.
Thank you,
We're
Mr.
going to
Chair.
go 5 more minutes, members, and
I
we have
hear
to
you.
wrap this up. We got another committee.
Trying to
coming
make
after
this
us.
quick. I'm looking for both of those things. I'm looking for the employer to have an opportunity to participate in the eligibility determination and to submit evidence. And if that's the current practice of the commissioner, that's great. I'm just looking for that to be in the bill. And then the second thing is, yes, I'm looking for something specific that allows the employer to appeal the eligibility determination. And it's something you suggested in that area I think would work.
Well, we'll turn to our testifiers.
Mr. Chair.
Senator Mann.
So right now, the employer does have that ability to contribute information and evidence and participate in the process. We do not have the employer being able to appeal because there's quite a big conflict of interest there. And so that's why that's not included. We don't think it's the right of the employer to go that extra step to make that decision.
Senator Kroon.
I guess, thank you, Senator Mann. Thank you, Mr. Chair, Senator Mann. I guess I'm not understanding what the conflict of interest would be here, because what I'm suggesting is that the employer would have an opportunity to participate. What I mean by participate would be submit evidence to the commissioner, but the commissioner would still be making the eligibility determination, and I don't see what the conflict is.
Ms. Fitzpatrick, are you?
I don't want to
can't tell
belabor,
what you're
I
trying
don't want
to
to
do here.
belabor the discussion unnecessarily. I mean, I think the idea, as Mr. Rowe mentioned, is that we're talking about medical certifications for the most part at this point. And again, the idea that an employer might have better medical information than the healthcare provider that's certifying that need for leave. I guess that's the question here, where the thought is that this is about these underlying conditions and whether they meet a medical standard, and whether or not, I guess the thought was that really isn't something the employer would necessarily have better information about. So that was kind of the structural approach.
Well, I agree with Senator Kroon as a matter of due process. The employer at least ought to have the opportunity to submit anything that they think is relevant, and then the benefits judge can make the decision whether it's helpful or not. Council has suggested amendments to accomplish these purposes. Ms. Primo.
Mr. Chair and members, after line 29.10, insert paragraph D, the commissioner must provide an opportunity for the employer to submit relevant information, period. Reletter the clauses, the paragraphs in sequence, and line 29.12, after applicant, insert or employer.
Senator Kroon.
I guess I would move to make that an oral amendment.
Senator Mann. Shall I have council read it one more time? Or do you got it?
I think I have it. So the first part makes sense, but the second part, the termination of eligibility or determination of ineligibility is final unless an appeal is filed by the applicant or employer. Is that correct?
That's correct, Senator Mann.
Yeah, so again, we're perfectly fine with the employer inputting information and contributing information and participating in the process, but then for the employer to file an appeal, would again mean that the employer would have access to this person's medical information, and there is a conflict of interest there, right? Because if I'm working for you, you don't want me to leave, you're going to appeal my request. And so while, again, I'm okay with the first part of that, I think that having employers file appeals is not a good idea.
Senator Kroon.
Thank you, Mr. Chair. I'd like to divide my amendment into two parts.
Which part would you like to take?
Uh,
First, the mover gets to make the decision, right? Senator Kroon, you're the mover of the amendment. You decide which part you'd like to take it first.
The first one would be the one that we seem to be in agreement on, with the employer being able to submit information.
All right, is there any further discussion on that portion of the oral amendment? Not seeing any further discussion. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Kroon, second part of the amendment?
Yes, I moved the second part of the amendment. And I guess I have a different take on that. I think that the employer, because what that would do is allow the employer to get into the spectrum of the benefit judge and the hearing that that entails. And so without the employer having that opportunity to appeal, they couldn't end up in that realm unless an employee appeals. So I would support a yes vote on that oral amendment.
Is there any further, so Senator Mann, your position is that you oppose the second part of this amendment here?
Yes, Mr. Chair. Again, in the case of a significant medical issue, it could be a very private medical issue. The employer should not be involved in that process. So
I'm sorry, Senator Mann, isn't the employer already involved in the initial determination? The question is whether or not they're allowed to appeal it?
No. So the employer can, again, under that new amendment, provide information that they have, but say that I am asking for time off for something extremely personal that I don't want to share with my employer. I don't have to share the specifics with my employer. And so having the employer appeal my decision that I've made with my doctor, I don't think that's the appropriate place for the employer to be inserted.
Senator Uma Verbate.
Thank you, Mr. Chair. This is under Section 11, is that correct? Is that within our jurisdiction?
I appreciate you raising the point, Senator, but this is closely related to the next section on appeals, which is within our jurisdiction, so I think I'll allow it to go to decision here. Understanding jobs can revisit it if they wish to. So, Senator Mann, or Ms. Fitzpatrick, help me understand this. If there's an appeal made, then the decision goes up to the commissioner to review everything and make a decision, right? Mr. Rowe?
Mr. Chair, so essentially, just to be 100% sure about where we're tracking, we're at 29.1. Are we on the subdivision 2, the determination section?
Yes.
Okay. So essentially, we take in information, the department takes in information from the applicant and now I guess the employer, and basically determines eligibility based on the criteria established in the statute. Then,
so if the decision maker here is the benefits judge?
Mr. Chair, so Rowe? For the determination, that's so the process considered within subdivisions 2 and 3, those are those are departmental activities.
Okay.
Once
So-
you get to the appeals section in section 268B.08, the appeals is where you get into the chief benefit judge.
I see. So an
The
appeal on
application.
line 29.11 would move it from agency decision to benefit judge. Is that right?
Correct.
That's correct,
Rowe?
Mr. That's my understanding.
And so the question before us is whether an employer should have the ability to move it to a benefits judge and out of the agency decision. Is that right, Mr. Rowe?
That's Mr. Chair, that's my understanding of the question at hand.
But within the agency, they'll have access to whatever information is supplied by the applicant, right, in order to make that determination. So, in effect, it sounds like the position being taken is that the agency can have this information, they can make a decision. If the applicant doesn't like it, they can appeal it, but if the employer doesn't like it, they're stuck? Am I reading that right?
Mr. Chair, so the intent is that when someone makes a request for benefits, it does not involve the employer for many reasons. So again, if it's something, a medical issue that I do not want to share with my employer, and I get the benefits, my employer may not have all the information, so they can appeal due to lack of information. We do not want the employer to be involved at that level because of that lack of information. And so to have them appeal, they can appeal at any time because they don't have all the information. This would prolong that person getting benefits potentially. And again, there is that conflict of interest there. And so for those reasons, again, I don't think that this is a good idea.
I'm having a hard time, Senator Mann, understanding how an employer can effectively participate in the process if they disagree with an agency decision.
Mr. Chair?
Senator Mann.
Again, they can submit information that they have, but they may not always have all the information. And so for them to not only submit the information, but then to be able to appeal it, we're going to let people without all the facts appeal these decisions. It just doesn't make sense.
All right, members, we have other, looks like other people coming in for the next committee that's scheduled for this room at 3 o'clock. So either we're going to wrap this up right now or we're going to have to lay the bill over. Senator Howe?
Mr. Chair and Senator Mann, wouldn't the employer have the family list that maybe there is no uncle or there's not another family member that was in childbearing age or something to that effect? Wouldn't they have a dog in that fight as far as having an appeal that the employee made application to a family member that doesn't exist? Would that not be pertinent to the determination?
Mr. Chair, would the employer have a list of the employee's family members? Is that what you're asking?
Senator Kroon. Senator Kroon.
Thank you, Mr. Chair. I guess this bill is broader than just an employee's health decisions. I mean, it encompasses a variety of things. We're talking about all of these related people, and an employer certainly should have an opportunity to participate in that aspect. We're not just talking about medical privacy issues here. So I think there has to be a mechanism for the employer to get this to the benefit judge. And the only thing I can think of is to make it equal so that the employer has a right to an appeal, just like the employee does from the agency decision. And that would, I guess, better track unemployment context too, which is, I think, the general overarching intent of this bill. So I do think this bill is so broad that the employer may have relevant information to Senator Howe's point. So I would encourage a yes vote on the amendment.
So, Senator Kroon, I'm inclined to agree with that, understanding Jobs Committee is going to also be able to take a look at this provision because it's clearly within their jurisdiction as well as within ours, I think, so. Is there any, so we have Senator Kroon's amendment before us, the second part of his original amendment. Is there any other discussion on that? I'm not seeing any. All those in favor of Senator Kroon's amendment, say aye. Aye. Opposed? No. The chair is in doubt. There will be a division. Council, I'm sorry, we're in the middle of a vote, but did you have some suggestions? I'm sorry, I forgot. Let's roll that back, because council had one other correction to make in the language here, so that whatever happens with the amendment, it's done right. Ms. Primo.
Mr. Chair and members, if we add or employer at line 29.12, we should also add or employer at line 29.22. Both of those are after applicant.
Okay, Senator Kroon incorporates that into his amendment?
Yes, Mr. Chair.
All right. Just so we're done procedurally, right, let's take it again. All those in favor say aye. Aye. Opposed? No. The chair is in doubt. There'll be a division. All those in favor, raise a hand. All those opposed, raise your hand. There being 5 in favor and 4 opposed, the amendment is adopted. Any further discussion on Senate File 2 as amended? Not seeing any further discussion. All those in favor say aye. Aye. Wait, there's a motion. Senator Mover Baton's motion is renewed. She made it.
Thank you,
earlier
Mr.
on.
Chair.
Go ahead.
I move that Senate File 2 as amended be recommended to pass and be referred to the Human Services Committee.
There we go. To that motion, all in favor, Senator Howe.
I ask for a roll call.
There'll be a roll call. The clerk will call the roll.
Chair Latz?
Aye.
Senator Uma Verbaeten?
Yes.
Senator Limmer?
No.
Senator Carlson?
Aye.
Senator Eichhorn?
No.
Senator Howe?
No.
Senator Kroon?
No.
Senator Pappas?
Aye.
Senator Seeberger?
Aye.
Senator Westland?
Aye.
There being 6 votes in favor, 4 opposed, the motion is adopted. Members, we are adjourned.